Madison's highest court ended the legal battle over Act 10 today.
But have we heard the last talk of collective bargaining in the governor's race? Since the governor's likely opponent says she wants to restore collective bargaining.
Balanced coverage tops Fox 11 News at 9. Good evening, everyone, and thanks for joining us tonight. The law that effectively ended collective bargaining for most public employees in Wisconsin was declared constitutional today.
That ruling from the state Supreme Court this morning. Here are the facts in the case. The court's ruling was 5-2, only Shirley Abramson and Ann Walsh Bradley dissenting. The justices said the state is not under an obligation to grant collective bargaining abilities. Act 10, as it's known, limits public workers to bargaining only over base wage increases, and those can be no greater than inflation. The law also requires public employees to contribute more toward their health insurance and their pension costs. When Governor Walker introduced the proposal in 2011, people protested at the state capitol for weeks. Many teachers and other public workers opposed the measure, and the Madison Teachers Union and a union representing Milwaukee public workers eventually sued. Fox 11's Andrew Lacombe joins us now. Andrew, on the story again today. And what about today's ruling and the governor's race?
Tom, Governor Walker said today the ruling proves his reforms work, and he hopes the state can now move on. Meanwhile, Democrat Mary Burke explained once again her stance on Act 10.
I support the right to collectively bargain. I don't believe that that stands in the way of making sure that we have efficient, effective, and accountable government.
However, Mary Burke says she does support the higher employee contributions that Act 10 triggered.
She's kind of gone this middle ground.
Lawrence University government professor Arnold Schober believes Burke wants to keep collective bargaining out of the governor's race.
I don't think she wants to make the campaign about that again. They tried to do that the last time. The Democrats tried to do that and it didn't net what they wanted.
Anger over Act 10 led to a 2012 recall election, but Governor Walker won, making him the first governor in U.S. history to survive a recall.
Act 10 works, our reforms work. It is a clear contrast between where we would do affirming that going forward, and if we elected somebody new who would chip away at that.
Walker says the law has saved taxpayers more than $3 billion. He attributes that to schools and local governments saving more money because of the higher contributions.
He's got to feel good that, you see, I did something that wasn't illegal, that wasn't wrong, that in fact is doing what, as he would claim, is doing what I claimed it would.
So would Walker's presumed opponent benefit from taking a firm stance on Act 10?
Going into this fall, I'm not sure that would help or hurt her one way or the other, because the state is so evenly divided that for her, she should probably avoid as many controversial discourses as possible.
If Burke is elected governor and wants to change part of Act 10, it could be a challenge. Republicans currently control the state assembly and Senate, and that may not change next year. Mary Burke has to win a primary election before she can run against Governor Walker. On August 12th, Burke will face State Representative Brett Hulsey of Madison. Hulsey said today if he's elected governor, he would call a special legislative session to restore workers' rights.